So I just wanted to thank you all for being up here for lunch and for the discussion so far today. As you all know, on the program, we have a sort of a 40-minute lunchtime dive during this slot. It's a bit of an experiment, informal setting. You're all standing, but I'm going to really hope for your cooperation that we can stop any background conversation because you have a fantastic lunchtime dive or panel in front of you. I'm going to start just by introducing Dominic Coppens, who's a professor international economic law at Maastricht University, and he's going to be moderating this session. My job was just to get you all in order. And if there's any talking, okay. All right. Okay, Dominic, over to you.
I'm very happy that Carolyn is responsible for the order and that I'm responsible for the substance. So much thanks, Carolyn. It's indeed spoiling a little bit your lunch, but it's on a super important and super interesting topic. So I hope you'll all stay with us. You'll have the opportunity to ask a few questions at the end as well. And as Carolyn already said, we have a stellar panel today with us to talk about the International Court of Justice advisory opinion that came out over the summer. And it was, for those who are not familiar with the advisory opinion, the court was asked to shine a light on the obligations of states under international law with regard to climate change. And what the court said is that indeed there is a duty on countries, on all states, to take effective climate action, and we're not there yet as of yet. Right, and so there was a very important finding made by the court, and we'll unpack that finding together with the panel. For those who want to read the advisory opinion, it's a very interesting read. It's a much easier read, I must say, than a WTO panel. And if you read the final paragraph, the court essentially says, and it calls on sort of human will and wisdom to tackle climate change. And I'm very happy with this panel that at least they're willing to share their wisdom with us today and shine a light on the implications of the ruling, in particular for the trade community. And I'm very pleased and honored that we have the ambassador of Vanuatu with us to deliver the opening remarks. As you may know, it was thanks to the will and the wisdom of Vanuatu and their students that the court was indeed able to put pen to paper and to deliver this advisory opinion. So, Ambassador, the floor is yours. We are very proud that you're among us to shine a light on this historic advisory opinion.
Thank you and good afternoon, everyone. I am a little bit scared of the earlier speaker about having some order here. But thank you for giving me the opportunity. I will spend the next 1 hour, 45 minutes to make this statement. Thank you, moderator, distinguished delegates, participants, friends. It is a great honor to address you today on the question that lies at the very heart of our shared future. The recent ICJ advisory opinion on climate and its implications for trade cooperation. The advisory opinion of the ICJ, delivered in July this year, represents a historic turning point in international environmental law. It reaffirms, as has been mentioned, that states have legal obligations under international law to take concrete, effective measures to address climate change and to protect the rights of both present and future generations. But beyond the law, this opinion creates a deeper message, a message of justice, accountability, and shared responsibility. It reminds us that climate change is not a distant or an abstract concern. It is a human story, one that touches every life, every economy, and every nation on planet Earth. For my country, the Republic of Vanuatu, as well as many of us here, climate change is not an environmental issue alone. It is a grave threat. And especially for us, islands scattered across the Pacific, we face the daily realities of rising sea levels, coastal erosion, ocean acidification, and increasingly destructive cyclones. Homes are washed away, crops are destroyed, and our ancestral lands, the foundation of our identity, are disappearing beneath the waves. Yet, Vanuatu and other small island developing states contribute least to global greenhouse gas emissions. We are among the smallest emitters, but among the first to suffer. And that is why we sought the ICJ's advisory opinion with your support. Thank you, everyone. To clarify not only what justice requires, but also what law demands of the international community in responding to this global crisis. The ruling places a legal frame around the moral conscience as law demanded that inaction in the face of climate change is not neutrality, but it is a breach of duty. The question before us today, how this advisory opinion affects trade cooperation, is both timely and vital. As we know, trade is the engine of global development, but it does not exist in isolation. It is deeply affected by climate change, disrupted supply chains, destroyed infrastructure, and the rising shipping costs are already undermining the ability of vulnerable economies to engage in global trade. Therefore, the ICJ opinion must now serve as a legal anchor for integrating climate obligations into trade systems. It calls on all of us to reimagine trade not merely as an exchange of goods and services, but as an instrument of sustainability and resilience. We must ensure that the international trade architecture must support climate action. Trade measures, whether carbon border adjustment, green subsidies, or environmental standards, must be designed with fairness and inclusion at their core. As the joint statement by UN experts at the UNCTAD 16 emphasized this week, states must prioritize human rights and planetary health, trade, investment, and business regulations. This means providing preferential access and technical assistance to small and vulnerable economies, supporting climate resilient infrastructure and low carbon industries, and aligning trade rules with principles of equity, common but differentiated responsibilities, and sustainable development. Vanuatu is taking bold steps to align our economic development with our environmental commitments. We are investing in climate change agriculture, climate smart agriculture, sustainable fisheries, and the renewable energy solutions that empower our communities and preserve our ecosystems. Our goal is to build sustainable value chains, one that create decent jobs, empower women and young people, respect traditional knowledge, and protect biodiversity. These are not economic policies. They are expressions of a belief, and development must serve both people and the planet. To achieve this, we need strong international partnership in technology transfer, investment, and capacity building. The ICJ opinion gives new legitimacy to such cooperation. It transforms solidarity from a matter of goodwill into a matter of legal and moral obligation. We call on our partners to help ensure that all countries, no matter how small, can participate fully in the global green transition. This includes access to renewable technologies, climate finance, and fair trade frameworks that value sustainability as much as competitiveness. By aligning trade with climate justice, we can turn vulnerability into resilience. We can create economies that thrive, not despite climate change, but because they have adapted to meet it. It is not only possible, it is necessary. The ICJ opinion reminds us that the cost of inaction is far, far, far greater than the cost of transformation. We stand ready to contribute, to share our experiences, and to collaborate with all partners in building a just and sustainable global economy. But we cannot do it alone. We need predictable climate finance, inclusive trade policies, and a renewed multilateral cooperation, one that leaves no nation behind. The ICJ has spoken. They have given their opinion. The law is clear. Now the responsibility lies with us, policymakers, negotiators, global citizens, to translate legal obligations into tangible action. Finally, what's next after the ICJ advisory opinion? In New York, Vanuatu is again taking some lead into having a discussion about how to operationalize the advisory opinion, and the efforts are now ongoing. We ask you all to please support your countries or our civil society partners to help us in that process as well. I thank you very much.
Much thanks, Ambassador Antos, for these very wise words on the moral duty, but also the legal duty that states have under international law, but also for translating them into concrete responsibilities for the trade community. With that, I'm going to move to the panel that we have collected here together, which is interesting because I was just looking at Carolyn, reminded that Carolyn already a few years ago called us and a lot of other experts on international trade and environmental law to reflect on principles for trade-related climate measures, to think about both the trade community and the climate community. And it's really nice to see, he even has a copy with it. Wow, Nick is still promoting that report. I highly recommend reading it. But it's interesting to see also how many of the ideas indeed that we tried to reflect in that paper also to some extent found their way into the ICJ judgment. So it's with a great pleasure to see some of these friends back. There are more even in the public today as well who are part of that expert report. Now, I'm going to first turn to David. I'm not going to introduce David. He has been introduced many times already this morning, and I think that just speaks to the expertise that he has. So David, without further ado, the floor is yours.
Thank you. In the limited time, I'm going to make some remarks on the question of attribution and causation, which are the secondary rules that were part of the advisory opinion. Parts of what one reads there is relatively uncontroversial and conventional in its thinking, and other parts are, I think, quite innovative. And I want to run through a few essential points and offer a few points of if not criticism, at least some questions that arise. So the first issue that I think is very, very important is that the rules on state responsibility and customary international law were affirmed, and that the essential argument that was made in respect of lex specialis were rejected. And oddly enough, there's an irony around this, because the efforts that certain countries had made in the Paris agreements and the like to avoid any recognition of compensatory responsibility, in a sense, came back interpretively to bite them, because it proved to be the basis upon which the lex specialis argument really couldn't fly, and hence the principles of state responsibility were reasserted. The manner in which that then was applied in relation to both attribution and causation is interesting in a number of ways. Partly conventional in relation to attribution as to what is attributable to a state in respect of the acts and omissions of organs of state, that very uncontroversial. What is much, much more expansive in the treatment given to attribution is the question around the manner in which private actions can be attributed to the state as a result of a failure by the state to exercise proper due diligence over the regulation of private actors. And of course, that is a hugely consequential part of the ruling, because it opens up what states have done by way of their regulatory activity to do and not do certain things in respect of what their private actors are doing within their economies. And this can go, amongst other things, to fossil fuel subsidies and a whole variety of measures that have very significant climate impacts. One criticism, at least perhaps possible, which some international lawyers may direct to this, is that there's, under the auspices of attribution, in a sense, the use of a secondary, the development of secondary rules starts to shade very much into primary obligations when one thinks about the rules of attribution. But those are possibly the matters for somewhat theoretical constructs in international law. And I'm sure probably this audience is not in the least bit troubled by the wide scope that has been given to attribution. Perhaps slightly more concerning is the treatment of causation. The court veered away from any very specific treatment of how exactly one determines individual responsibility. And they simply said that in essence you can apply their standard treatment of causal principles, and there will be a way in fact-specific circumstances of determining individual state responsibility. Now here, I would just say that I don't think conceptually that all of this was entirely carefully thought through. It works at a very high level of generality. And just to give you one illustration, because time is short, once one says that responsibility in respect of attribution relates to omissions, then the question as to how factual and legal causation are going to work in relation to omissions by a state in a multi-causal problem as to what is causing effects seems to me to be a hugely difficult question to thread your way through, and most especially under what would have to be counterfactual reasoning in relation to omissions. And I think the treatment of this is somewhat superficial and frankly rather underestimates the complexities that are deeply embedded in that problem and set of problems around causation. And with that observation, I will cede the floor.
Thank you, David. Just maybe to put David's remarks into context. So the court had two questions before it. The first is sort of primary obligations. What are the obligations of states under international law with regard to addressing climate change? The second question on which David was opining is what happens if a country has indeed violated its primary obligations? What are the responsibility? Could such a state be held responsible for the injury that it has caused as a result of its actions or in inactions to other states? Now, I'm going to move on to Gabrielle, which also does not need much of an introduction in this city. She is the honorary professor of international public law and international organizations at the University in Geneva, but she was also for, I think, more than 30 years senior counsel at the WTO, where she was sharing her wisdom with panelists and researchers. So we're very happy to have you, and the floor is yours.
Thank you, Dominique. Thank you to Tess for inviting me. I hesitated very much in coming here because I'm not an expert in public international law. But at the same time, the issue is so important that I thought I'll come here and say my plan is to say, draw your attention on 2 or 3 points of this enormous judgment, then try to bring this to WTO, and the last part, all this in 1 minute each, I suppose, on the future. So yes, we could say that there's nothing terribly new in this report, except that it confirms things that have been said and understood, such as the obligation to act, the duty to cooperate, that will be extremely important, but as both an obligation of result, but also an obligation of conduct, and the obligation to take all means possible for dealing with climate. And of course, trade is one of those means. Trade is also a way to collaborate. And then the very innovative approach, I think, where the court recognized that the CBDR principle is really a dynamic principle, and it's not a developing and developed country approach only. So just two or three quotes. I want to be quick, and also interesting separate opinions. There's no dissenting opinion because they wanted this to be unanimity. But you have, for instance, a Chinese judge who, contrary to the majority, will say, in my view, CBDR brings obligations, while the majority had said there's no new obligation brought by CBDR. It's a principle useful for interpretation. So, just this sentence, for instance, the principle of common but differentiated responsibilities and respective capabilities does not establish new obligation, but is relevant as a customary principle. As I mentioned, this is different from the duty to cooperate, which is an obligation. How to do it is a distinct issue. I could go on and on. I had prepared all sorts of things, and the 5 minutes brought me back down to earth to say that if we look in the context of the WTO, one of the existing tension that is there for years, that was recognized in Japan Tax's appellate body report, is the need to always look at equivalences. When the appellate body said that the rules for tax and the rules for regulation under national treatment should have the same scope and eventually the same result. Why? Because it doesn't make sense for a government to treat more severely tax than regulation. When I left legal affairs to go to research, this was my argument for my interview. We need to study equivalences, mutual recognition in digital, but also obviously in climate. And this is how I think the matter will come in the WTO. As I mentioned, we have limited but existing principle on equivalence. And it is in particular, if I jump quickly, in the context of the case law on Article 20, the important shift of the case law in Brazil Tire was that when an exporting country points to an alternative measure that is reasonably available for the importing country, this should be examined. Well, these alternative measures, I suppose, I remember hearing the Indian ambassador explaining how in steel, they don't do things the way the EU thinks it should be done, but their way is good, if not better. The difficulty will be to compare those things, because if it comes as a dispute at the WTO, this is what will be examined. Importantly, as I mentioned, CBDR, it's been a high tension in the WTO, developing. And again, I'd like to read just one small excerpt of this paragraph where the court says that what is to be done under all the means at its disposal. There's a recognition that there's an obligation, but not all countries do the same. It says word for word, it cannot be just an issue of developing. It cannot result merely from this distinction. It must also depend on their respective national circumstances, and it's a multifactorial sort of determination. And this was arguably recognized in the Paris Convention already, where the general principle of CBDR was a bit set aside in favor of national commitment that each country decide what they can do and not do. Now, in my view, this is where things get extremely sensitive and difficult. And it's the issue of conflict between WTO and Paris or other things. In WTO, one of the principles is that each state can determine the level of protection they want. This was a battle won by the EU in hormone and repeated. But arguably, some developing countries have said, I don't want to do more on climate than what I promised in Paris. For me, my commitment in Paris is the only thing I wanted to do. Others would say, well, the world is fragmented, and unfortunately, you need to do a bit more. I have the right to have higher sort of a standard. There's no answer to that. It needs to be discussed. It needs to be discussed in the context of cooperation. And I would finish in simply saying that today's reality for me, I'm a bit depressed with what happened in the Maritime Treaty, with EU having to, under US threat now, give up or reconsider all its environmental sort of background to the extent that it may restrict trade. So a lot of energy will have to be devoted to go back to those equivalents. What is it? Assuming we all need to do something, what can you do? What's your maximum? And should it be discussed in the WTO? I'm not sure. But I'm sure that the WTO with TBT and its mutual recognition experience can help this step forward. My very last point is that an advisory opinion can be very useful, even if it's not binding, etc. And this is why I believe if we are to have an appeal stage, again, which I hope, maybe one first step is to have exactly that, only advisory opinion, so the law is rigorously followed, interpreted, and applied, and not necessarily followed afterwards, but the law is respected.
Excellent. Thanks a lot, Gabrielle. Very interesting remarks about indeed the primary obligations of states under international law, one of them being the prevention obligation that needs to be read in light of important principles. The principle of cooperation or the duty to cooperate, very important, which also resonates with what we discussed this morning. Also, the principle of CBDR, I think you rightly said that it's a spectrum, right? And that's long recognized already in the climate treaties. It makes it also less scary for the trade community, which oftentimes still thinks this is a binary concept, but the court now also recognized that's not the case. It is a spectrum across which all countries sit that results indeed in different responsibilities and duties, and that is an important principle to take into account in the interpretation of international law.
Be difficult.
And it can be very difficult.
I'm not saying each country. This was raised by Malaysia and Shrimp, and everybody said not each, but maybe groups of countries.
You see, I failed in summarizing, or at least I wasn't done yet. I was not going to say it was easy. It's not easy. And with that, I'm going to move on to Nick. Introducing Nick is also not easy because I've worked for 14 years already with Nick, and people you know quite well are difficult to introduce. But Nick is leading the ESG practice at Sidley Austin here in Geneva. He's one of the few who is both passionate about trade law, being a WTO trade litigator for years, but also passionate about climate law. He has been leading Sidley's efforts to support Antigua and Barbuda in the advisory opinion before the ICJ and the African Union in the ITLOS advisory opinion. So I think very well placed indeed to take the floor here and to come indeed with easy solutions to difficult problems, right?
Thanks, Dom. Thanks, Dom. One of my great professional pleasures has been the 14 years I've spent working with Dom, and I'm sad to say that those 14 years are coming to an end. And Dom is moving on to other things, and I wish him all the best with that. He's exceptional in many ways, including his moderation of this panel. So to the ICJ opinion. So we've been talking about climate change for many years in many different fora, including at the WTO. And there are always debates around climate change, in particular around the law relating to climate change. And I think one of the enormous values of the advisory opinion is that we now have, as the ambassador said, clear answers to many of the legal questions that relate to climate change under international law. The ICJ really grasped the nettle and has given us a lot of extremely rich material. If you followed the press around the advisory opinion, you will see it has been described as historically significant. And there's lots of reasons for that, but there are two that I want to highlight. The first is that the UN General Assembly sought the advisory opinion on the basis of consensus. That's the first time that's happened in the advisory practice of the ICJ. The second is, as Gabrielle said, that the advisory opinion was issued unanimously by all 15 judges of the court. That is also extremely unusual in the practice of the ICJ on advisory opinions. Why does that matter? It matters because it lends weight to the opinion. So when we are debating climate change, trade-related climate measures in the WTO, we now have a new element that we absolutely have to take into account to the extent that we're interested in the rule of law, which I think most people in this room are. So that's the first point that I want to make. It's extremely important, and it lays out a lot of answers to legal questions that we've been debating for a while. So it has to change the conversation in the WTO. The second thing I want to highlight is the approach that the ICJ took to interpretation. So the ICJ was asked to review all international law relating to climate change, an enormous task. The ICJ focused on the climate treaties, on certain other environmental agreements, in particular the ozone treaties, the Treaty to Combat Desertification, and the Convention on Biological Diversity. It looked at law of the sea, it looked at human rights, and it looked at customary law. So a really wide range of international law that touches upon climate change. Now, there were debates before the court that some of these rules conflicted, and that the court should therefore only give effect to the ones that dealt specifically with climate change. The court rejected that, and it did so on the basis of a very well-established proposition, which we know in the WTO, which is where multiple rules of international law bear on a single issue, then the adjudicator must, as far as possible, give effect to all of the rules as a single set of compatible rules. Now, when we think about the climate regime and when we think about trade-related climate measures in the WTO, that principle must guide our work. We're looking for a single set of compatible rules drawn from all parts of international law. The third thing I want to touch upon is two things that the court said about customary international law, which are really significant. The first is to declare that there is a duty of cooperation as part of customary international law. That's the first time that cooperation has been articulated in that way as part of customary international law by the ICJ. ITLOS did it in the advisory proceedings last year, but the ICJ has picked that up. So that changes the game when it comes to the way we think about cooperation in the WTO, whether that's for purposes of the chapeau of Article 20 or anything else. It is a duty under international law to cooperate. And the ICJ gave a particular shout out to the need to cooperate when states adopt unilateral measures that have a climate change objective. You have to cooperate in the process of adopting that measure, but also after the measure has been adopted. The second thing I want to highlight from custom is the explicit recognition that the duty of prevention includes the precautionary approach or principle, which is also the first time that the ICJ has stated that, and has also been something that we've debated for many years in the WTO. There's a stronger legal underpinning now for the approach that we take to the precautionary approach. Then I want to finish on what the court called certain other principles that are relevant to the interpretation of treaties and to the determination of customary law. And those principles are, first, the principle of sustainable development, which should guide our interpretation of treaties and international law. The second is the principle of common but differentiated responsibilities and respective capabilities in the light of different national circumstances. It is a principle that the court has relied upon and has said must guide the interpretation of treaties and international law. And just a final word then on those two principles. To Gabrielle's point, for CBDR, it is a spectrum. The court actually uses that word, and the court highlights that all states have responsibilities, irrespective of their state of development. But the more you develop, the more stringent your duties under the climate treaties, customary law, law of the sea, human rights, all those other elements. But when we think about trade policy and trade measures, we must take into account all of these elements. They have to be part of the conversation. The ICJ has made that crystal clear.
Thanks, Nick. Excellent summary on something that is indeed close to your heart, on thinking about how to build a bridge essentially between Paris and Geneva, and explaining how the court has used interpretive principles essentially to construct that bridge with a clear duty on states indeed to walk essentially from one to the other. That brings me to the final panel expert, Elena. It's a great pleasure to have you among us as well. Elena is senior lecturer in international environmental law at the University of Geneva. I'm always really jealous about Elena because she can genuinely say that she has deep expertise in both climate change law and in trade law. She's one of the few out there who can genuinely claim that that's indeed the case. She is, of course, therefore also very closely following the debate on energy and the move towards renewable energy. And she's also organizing a great summer course at the Geneva University every year, bringing together experts and students around the world. And she has helped us and Antigua and Barbuda also in the advisory proceedings before the ICJ. So Elena, the floor is yours.
Thank you. Thank you so much, Dom. I think I'm going to let everybody down after this introduction, but I just want to make a few points. And being the last speaker is, I have kind of the advantage of being able to also comment a little bit on what the other speakers have said. I just want to make maybe initially there were 5, there might be 6 quick points based on what has happened in the panel. The first 3 are not immediately related to trade, but they're still, I think, very important contributions of the court in the context of the advisory opinion. And the last 3, I think, very much relevant for our discussions today and tomorrow on trade. So just going back to the reasons why the opinion was requested in the first place. Part of the reasons was to just provide more certainty as to what is the content of states' obligations, both in treaty law and in customary law, and what role for customary law in this regard. So I want to make a first point on custom. Nick already covered cooperation and a few other principles. I wanted to quickly speak about the duty to prevent significant environmental harm. Now, it's a principle and a duty that traditionally has applied to transboundary, cross-border environmental harm, but the court was extremely clear in stating that this, of course, applies as well. And we can say, of course, now, but it applies as well to global environmental concerns such as climate change. It's, of course, a duty of due diligence, nothing new there. But then, while the standard of due diligence is a standard that depends on the facts and the circumstances of the case, in this specific situation, the court told us that we can already determine, a certain required standard of due diligence at the general level because we know very, very well what the risk is. And we know that it's urgent and that it's general, thanks to the science provided by the IPCC. And this requires a stringent standard of due diligence. So there's already something that we know. Then, of course, we'll have to, nuance it based on CBDR-RC, but there's already this very stringent standard of due diligence. On custom, moving to treaty law, in particular Paris, there as well the court has interpreted quite robustly the commitments in the Paris Agreement. I'm thinking of the 1.5 degree, the global, seemingly aspirational temperature goal, which is instead interpreted as a hard legal requirement, which informs all the other provisions in terms of mitigation in the Paris Agreement. An important question that the court addressed is to what extent and whether countries, for example, have discretion in determining the content of their NDCs. And here the answer was that the discretion is limited. Is limited because of the language of Paris, but is also limited precisely because of this target. So there is a discretion in determining the content of NDCs, but countries have to exercise due diligence. So customary law here intervenes in the interpretation, and they have to ensure that their measures, their NDCs, their contribution will adequately contribute to achieving the global target. So that 1.5 is really a legal requirement. And this takes me to my third point, which is, related to the relationship between customary law and treaty law, also very important contribution of the court. On the one hand, Of course, customary law can, guide and influence treaty law, but those are two very separate, distinct set of rules. So this is an important point. Complying with Paris doesn't mean that a state is complying with its duties under customary law. There are two different sets of obligations. And now, three shorter points, more related to trade. The first one, we already touched upon it, is this emphasis on systemic integration and harmonious interpretation, which I think is extremely important when looking at other areas of international law and the role that this opinion and climate rules in general play in interpreting those other sets of rules. Another important point is linked to the discussion on attribution that David was mentioning. He mentioned fossil fuels. This is something Dominic and I, as we worked together, we were live listening to the delivery. And when the court singled out a set of activities linked to fossil fuels as potentially, violating international law, this was a very strong statement. So the court was quite clear in stating that, failure to adopt all appropriate measures to protect the climate system, including, and it lists fossil fuel production, licenses, subsidies, it may constitute an internationally wrongful act. So it could engage state responsibility. This is, I think, extremely relevant for many of us in the room in terms of the kind of discussions we can have at the WTO, in terms of what's happening in some regional forum, thinking of the ACCTS, for example, that deals with prohibition of fossil fuel subsidies, the plastics negotiations, climate litigation. And this takes me to my final point, picking up on what Gabrielle was saying. Advisory opinions are super important. They are not binding, but they have historically, in particular the ICJ, they have played a very powerful role in pushing negotiations. Some principles or concepts have then found their way in actual treaties, in influencing domestic and international litigation, and in changing state behavior. So just kind of something to think about, the influence that it can have. Thank you very much.
Excellent. Thanks, Elena, and thanks for reminding us about that important finding indeed on fossil fuel subsidies, which will indeed give traction to efforts to reduce fossil fuel subsidies around the globe, but also in explaining that essentially for states there is no way out, right? The court clearly said that there are demanding obligations under the Paris Agreement, but also if you're a country like the US who likes to move out of the Paris Agreement, you're not let off the hook. You're still subject to similarly stringent obligations under customary international law. We'll do one round of questions. We'll take a few questions and then I'll leave it to the panelists to see which questions they want to respond to. I think there is a mic.
Thank you, Taka from the Japanese mission, and thank you all for the explanation. I did have a burning question, and it is exactly on this point of 1.5 degrees as your primary goal. I happened to be in COP21, and it was very clear that 1.5 kind of came at the end. There were, subsequent COP decisions, but I think the negotiators thought they had left enough wiggle room about the interpretation, but the court actually took a very hard line on that point. I think there's definitely an analogy with what happens in the appellate body with the hearing, for instance, when you kind of interpret, when members feel that what they negotiated is not being interpreted faithfully afterwards. And also, I think there's a very practical effect on trade officials. Basically, so we are working on this little proposal in the WTO, in the Committee on Trade and Environment. I have had some people who are very opposed to the EU CBAM, basically saying that if we agree to this, won't this be a subsequent agreement that says that we have legitimized the EU CBAM, because this is kind of related to it, even though in their view, the CBAM is not allowed under the WTO, that's their view. But they fear that if they negotiate anything that seems to be providing cover for that, that will be interpreted as a subsequent agreement that allows for that. So there's this very real effect on people on the ground in negotiating. And you mentioned maybe that it would help negotiations. I personally fear that actually it will push back the negotiations as people become more cautious. So any opinions on that would be very useful.
Thanks. Really quick, Bernardo Arce from ODI Global. Thanks, it was really interesting. I'm not really familiar with other advisory opinions, but I'm familiar with the Inter-American one. So I'm just curious if you know about other regional rulings on this regard. If I'm not mistaken, there's one on the African court as well that is upcoming. So I'm just curious about the different initiatives also on regional courts and eventual differences or complementary findings between them, because in the Inter-American one, in fact, there's a section on trade and investment. It doesn't go much into the details, but it's interesting to see that the Inter-American one went into that regard.
Yes, thank you very much for this very interesting conversation. I think Professor Masso gave some clear answer from a legal point of view of the implication of possibly the CBDR as an interpretation. But the question is rather politically. Because in the WTO, when we are also discussing the Japanese proposal, there's a lot also of, let's say, a little tensions about this principle coming from the UNFCCC within the WTO. And here you have maybe some opposed, how do you say, different positions, let's say. How would you reconcile now this debate in the WTO, politically speaking, with this ICJ advisory opinion? And second question also with regard to cooperation, how would the cooperation obligation help discussions, for example, on trade environment in the Committee of Trade Environment in the WTO? Thank you.
You get a minute 5. So yeah, that's fine. We'll go around, and you can just be selective in choosing the questions. These are just on very neutral concept like CBDR and CBAM, abbreviations that are not very sensitive in this town. So this should be easy to address in a minute. So I'm gonna share the floor first with David for your final minute.
Well, I'll just pick up the interpretation point, because I think it's just always a hazard that exists when you put texts to courts, even ones that yield advisory opinions that aren't technically binding but are influential, that the way in which they see the text and its purpose and context and so on, it just turns out to be different from what happens in the heat of negotiation and what people thought they were taking away. And I mean, that is not confined to legal interpretation, that's confined to literary criticism and all sorts of other things. So it is just a function of the institutional role that courts play versus those who put the pieces together, and that there should be a measure of difference and distance between them is almost inevitable. And perhaps one just has to be reconciled to that. The problem, though, is sometimes the reconciliation is impossible, and it comes to affect the very legitimacy and institutional standing of the court. I don't suggest that is true of the ICJ in respect of this opinion at all, or not yet at any rate from the reaction. But there's a subtle relationship between a court or a body that makes interpretations and the constituency to which they are responsible. And that moves back and forward, but it should never move in such a way as to lose the complete confidence of those who give the interpretive power to the body in the first place.
Thank you. I fully agree with what you just said, and maybe it's a first step to my answer on CBDR. And I mentioned equivalence. To me, the same thing can be said of CBDR. That is, whether or not it's a general principle, we know it's a principle for climate law now, it's clear. 2 years ago, the ILC refused to list CBDR as one of the general principle, but to me it was not an issue because it is within the WTO, within sustainable development that is clearly in the WTO and in the chapeau of Article 20, for instance, where it says that you should compare situation, but between countries in the same conditions. So I think we have to look at all this as tools to help governments implement their general obligations, because there's a distinction between obligations of a state under several treaties and the obligation of WTO members. And as I said, I think that trade is a tool to implement all those obligations of state, to also cooperate, etc. So in the context of implementation, I finish with this. One particular sensitive issue is that of transfer of technology and local content and the possible exceptions of 20. And I don't have the time to go into details, but I think that obligation of transfer of technology can really be read differently after this report in giving space to developing country to require that, maybe in the context of local content that could be justified, but there's some things that can be done, even if CBDR is, in my view, repeated a little bit as the appellate body did with the precautionary principle in hormone, repeated within the WTO. Thank you.
Thanks very much. On the question about the different advisory opinions, evidently in a minute, we're not going to get through the differences and complementarities. I would say that they are extremely similar in the approaches that they take, especially ITLOS and the ICJ, but also the European Court of Human Rights in a non-advisory opinion. The Inter-American Court has gone further, including declaring part of international environmental law part of jus cogens, which is quite far-reaching. To Nellie's question, where do we go from here in discussing climate, and I would say more broadly environmental issues in the WTO? I think the ICJ opinion has provided us with a set of principles and norms that need to inform the conversation. I think if you try and take one or more of those principles off the table, you will not succeed in having a conversation, because no member of the WTO is going to read the advisory opinion of the ICJ and come to the conclusion that, I think reasonably, that there's no role, for example, for CBDR in the WTO. So to me, it resets the conversation. And all of those elements of the ICJ opinion that I mentioned need to be part of the conversation. How you operationalize them is both a political question and a legal question. There's lots there for everyone. There's the principle of there's cooperation, there's precaution, there's sustainable development, there's CBDR. But all of that needs to be on the table as part of an open and honest conversation about how we use the collective will and wisdom to tackle a problem that faces all nations and all people.
Thanks, Nick. What is on your point on the impact on negotiations? I agree with you. I mean, I think that there is that also the possibility that countries will be more cautious. I think it depends on which negotiation we're talking about. In climate, probably. When they were drafting the Paris Agreement, I'm sure countries were not thinking of how those numbers will be used in the future. So that's definitely a possibility. And going back to also the different opinions, in this case in particular, the ICJ had a lot of time to learn and read from the ITLOS advisory opinion, and there are a lot of references to that. The Inter-American one came out just before they were drafting, so they had a look at it. And they also, I think it's important also to keep in mind that the different context. ICJ is, of course, UN judicial organ, so all UN membership, all of international law. ITLOS is a specific treaty, not all countries. Inter-American Court is a specific region. It's more progressive also because historically, through its advisory opinions, the court has been extremely progressive. It reflects a certain reality which is not maybe necessarily, applicable to, I think, to the rest of the world. But the African Court, I mean, I'm extremely excited about that because it's been, I think, even more progressive in the past. So we're going to see what's going to come. But there's a lot of cross-fertilization, so that's powerful.
So I'll just speak, I suppose, from the perspective of diplomats here, as a diplomat. Is the responsibilities for having these discussions and negotiations. It's not easy, it's difficult. And sometimes here in Geneva, I get the impression that some of us, some members, are not ashamed to protect what cannot be defended. And so we always go back to our obligations, what they are. And so I think in the next few months, next few years, is to consider our global responsibilities. How do we go about doing that? And I say this because a couple of weeks ago we were having discussion on the Plastics Pollution Treaty. There was a failure in arriving at some sort of resolution of what we want. Why? We know the reasons. Only 2 weeks ago, or is it last week, we worked very hard on a Human Rights Council resolution on sea level rise. We pushed a lot of the one of the issues raised at the advisory opinion, which was listed, what are the causes of the climate change? Some natural human causes, some fossil fuels, subsidies, and so on. So we tried to include that language in that UN Human Rights Resolution. There was a very big pushback. And at the end, Vanuatu had to withdraw this proposal to include that specific language, which was very unfortunate. And for us to try and build consensus here in Geneva. But I hope in future that kind of pushback should be diluted and we refer to our obligations as has been highlighted today. So there's a lot of work for all of us. And those non-government organizations who are here, as I said, please keep supporting the efforts that are being pushed in Geneva. Merci.
Thank you, Ambassador.
10 seconds, because I'm the oldest.
Seems to be a fair.
10 seconds. Just to support what the ambassador just said and what Nick said, that we have to put everything back on the table proposed by Brazil, its new proposal, let's not just limit it to WTO&F, let's take it out and put everything on the table is more important than ever, I think.
Excellent. That's a great way to finish this discussion. So before we get all around our table again to take on the challenge that the ambassador laid out and get the work done, I think the people have deserved the coffee, right? Thanks for everyone.